All right, in today's video, we're diving into exactly when an email or a text becomes a real binding contract in Florida and when it's just noise. Getting this right is everything because knowing the rules can be the one thing that saves you from a career ending mistake. We'll look at the laws, the court cases, and the practical steps you need to take to protect yourself and your deals. I'm Santiago Cueto, board certified international business law expert and best selling author based right here in Miami, Florida. In today's digital age, many of my clients are surprised to learn how a simple text or email exchange can have significant legal implications. Imagine this: you've just hammered out a massive real estate deal for your client, and after some back and forth, you get the text from the other agent in capital letters that says, "We have a deal, $3.4 million accepted." You're already celebrating, mentally spending that commission, and getting ready to give your client the amazing news. But then the phone rings. The deal is dead. The sellers got a higher offer and they're walking. That text message, that whole informal email chain that spelled everything out, it's suddenly worth less than the pixels it's displayed on. Now, this isn't just some made up nightmare, it's a scenario that happens all the time in Florida business and real estate. As someone who deals with Florida's tangled legal world every single day, I can tell you that contract law is one of the most misunderstood areas, especially now that we live our lives through screens. That broker who lost that deal over a text, he learned a very expensive lesson about a very old law. It's called the Statute of Frauds. So, what is the Statute of Frauds? It sounds dramatic, but it has almost nothing to do with what we think of as fraud. It's an old legal rule from England, and it was created to stop people from making false claims about major deals. The main idea is simple: some contracts are so important that they are completely unenforceable unless they're in writing and signed by the person you're trying to hold to the deal. Here in Florida, the Statute of Frauds is found in Florida Statute Chapter 725, and it applies to a specific list of contracts. The big ones for professionals include any contract for the sale of real estate or any lease that lasts longer than 1 year, any agreement that can't possibly be completed within 1 year, a promise to pay someone else's debt, also known as a guarantee, contracts for selling goods worth $500 or more, and certain agreements related to marriage. These categories cover most of the high stakes work that we do. This is exactly where our broker's text message deal went off the rails. And this isn't just a story, it's based on a real Florida case, Walsh versus Abate. In that case, the agents for the buyer and seller seemed to agree on a $3.4 million price for a house through emails and texts. But when the seller bailed, the court refused to force the sale. Why? Because a real estate contract is covered by the Statute of Frauds, and that messy chain of texts and emails wasn't good enough to count as a single signed contract. The court basically said that even with all the electronic chatter, the deal failed to meet the higher legal standard requirement. You're probably thinking, hold on a second. We sign stuff on our phones and close deals over email constantly. Aren't there laws for this? And you're 100% right. This is where things get really confusing for a lot of people. Florida, like most states, has laws to bring contracting into the 21st century. The two big ones are the Federal E-Sign Act and Florida's own Uniform Electronic Transactions Act. These laws were designed to give electronic messages the same legal power as old school documents. The act even says that a contract or signature can't be thrown out just because it's electronic. For a basic contract to be valid in Florida, whether it's on a napkin or in an email, it just needs three things: an offer, an acceptance, and consideration, meaning both sides are giving up something of value. As long as everyone is on the same page about the main terms, a series of emails or texts can absolutely get the job done for many agreements. Even better, that act defines an electronic signature in a really broad way. It can be a sound, a symbol, or a process that you attach to a document with the intent to sign it. That means your typed name at the end of an email, your company's signature block, or even clicking an I agree button can be a legally binding signature if you meant for it to be. This is why you can agree to terms of service online or finalize a simple project with a client over an email, and it's usually perfectly enforceable. This is where things get both efficient and incredibly risky. It's easier than ever to make a deal, but it's also easier than ever to accidentally get locked into one. I'm curious, have you ever closed a deal using only emails or text? Drop a comment below and let me know how it went and if it ever got messy. And if you're finding this information valuable, do me a favor and hit that subscribe button. We put out videos like this to give you the insider knowledge you need to protect you and your business. All right, so here's the $1,000,000 question, the one that cost our broker his commission. If the Electronic Signature Act says electronic messages are legally valid, why did the $3.4 million real estate deal fall apart? Well, the answer is a direct clash between these two sets of laws. Think of it this way. The Electronic Signature Act is the general rule for the modern world. It says electronic records are usually fine. The Statute of Frauds, however, is the very specific exception to that rule. It slams the brakes on and demands a much higher standard for those few high-stakes contract types. For those special categories, real estate deals over a year, etc., it's not enough just to have a digital chat. You need a signed writing with all the essential terms baked in. While the Electronic Signature Act says an electronic record can be the writing and electronic signature can be the signature, the whole package still has to satisfy the Statute of Frauds' tough requirements. A jumbled chain of informal texts, like in the Walsh versus Abate case, just doesn't cut it because it's not a single cohesive document signed by the key person. The court saw negotiation, not the final signed agreement that the law requires for real estate. But this is where it gets even trickier and, frankly, more dangerous. Sometimes a text message can be enough to satisfy the Statute of Frauds and lock you into a contract you never saw coming. This was proven in another major Florida case, Brewfab versus 3 Delta. Here, a company named Brewfab was owed a lot of money. The owner of the debtor company, George Russo, sent a text that said, I, George Russo, from 3 Delta, do promise to pay Brewfab in full all outstanding bills and all agreed upon work done for 3 Delta future forward. When the company flaked on the payment, Brewfab sued Russo personally, arguing his text was a personal guarantee to pay the company's debt, which, remember, is covered by the Statute of Frauds. The court agreed. It decided that Russo's text, by clearly identifying himself and spelling out the promise, was a signed writing that met the standard. That one text made him personally on the hook for over $350,000. Now, the takeaway here is pretty chilling. The exact same tool, a text message that failed to seal a $3.4 million real estate deal, successfully created a $365,000 personal debt. The difference was all in the specific wording and how clearly it met that high legal bar. All right, knowing the law is one thing, but using it to keep yourself safe is what matters. Let's move from the what to the how. Here are 4 strategies every professional in Florida should start using yesterday. First, and this is the big one, the formal contract is king. Treat your text and emails as tools for negotiation, not for closing. The second you have an agreement on the key terms of any deal that falls under the Statute of Frauds, your very next move must be to get it all into a formal written contract for everyone to sign. For real estate, use a proper sale and purchase agreement. For other deals, get a real contract drafted. Do not bet your deal on an informal exchange over a text message. Second, use protective language. Since you can't accidentally create a contract, you have to make your intentions crystal clear in your emails and texts, especially when you're negotiating. Add a simple disclaimer, something like, for discussion purposes only, not a binding offer, or the more formal, the terms herein are non-binding until a signed Final agreement is executed. This little sentence signals to everyone, including a judge, that you didn't intend for that text to be the final word. Third, recognize the danger zones. You need to have your radar on high alert for situations involving the statute of frauds. If you're talking about a real estate deal, a business project that will take over a year, a personal guarantee on a loan, or a big sale of goods, alarm bells should be ringing. These are the moments when a casual "we have a deal" text is most likely to either be worthless when you need it or binding when you don't. And fourth, document everything. While a string of text might not create a valid real estate contract, that doesn't mean they're useless. These messages can be powerful evidence to show what a party intended, to clear up confusing terms later, or even to support a claim for misrepresentation. Keep clean, complete records of your electronic communications. They tell the story of the deal, and you'll want that story on your side if things ever go south. All right, so let's circle back to our original question. Do emails and texts count as contracts in Florida? The answer is a classic lawyer move. It depends. For many everyday deals, yes, a clear email chain with an offer, acceptance, and consideration can absolutely be a binding contract thanks to laws like the Electronic Signature Act. But for the big stuff, the deals that define your career, real estate, long-term agreements, personal guarantees, the answer is a hard no unless that digital message is so clear and so explicitly signed that it clears the very high bar of the statute of frauds. As we saw with the Walsh and Brufab cases, the line between an unenforceable text and one that costs you hundreds and thousands of dollars is terrifyingly thin. Look, relying on casual messages to close major deals isn't just bad practice, it's betting your commission, your client's future, and your reputation on a legal coin flip. Getting this right isn't just legal trivia, it's a fundamental part of managing your risk. Now, if this breakdown was helpful and you want more practical legal tips to protect your business, do me a favor and hit that like and subscribe button. It really helps the channel reach and empower more professionals just like you. I'm Santiago Cueto, your Florida business attorney. Be sure to subscribe and watch more of my videos right here.